I'm Roger Baker, Executive Director of the Stratfor Center for Applied Geopolitics at RANE, a global center of excellence for geopolitical intelligence and analysis. Learn how you can put geopolitics to work for your organization at ranenetwork.com.
Hello and welcome to the special edition episode of the RANE Insights series from RANE Network. In part one of this two-part podcast, RANE founder David Lawrence sits down with three leaders in cybersecurity and reputation management: Rahul Mukhi, Kimberly, and Kellyn Wagner Ramsdell. Rahul Mukhi is a partner at Cleary Gottlieb, specializing in investigations, enforcement, and regulatory matters, as well as complex commercial litigation. Rahul joined Cleary Gottlieb in 2005. From 2010 to 2016, Rahul worked in the U.S. Attorney's Office for the Southern District of New York as an Assistant U.S. Attorney. He was a lead prosecutor on significant cases involving public corruption, cybercrime, financial and tax fraud, healthcare fraud, money laundering, and international organized crime. Kimberly, partner and head of Houston for FGS Global, advises clients on reputation management, financial communications including M&A, shareholder activism, and restructurings. She specializes in crisis and issues management, including responding to and preparing for cyber incidents as a senior member of the cyber team at FGS Global. Earlier in her career, Kelley founded Kimberly Public Affairs and served in several leadership roles at Enron. Kellyn Wagner Ramsdell is the Associated Director of Threat Intelligence at RANE, responsible for enabling the delivery of high-quality, clear, concise, and correct intelligence products that enable decision advantage. Kellyn has wide-reaching investigative and intelligence analysis experience in incident response, law enforcement, and the U.S. intelligence community. She's an expert in tracking and disrupting cyber advisory infrastructure and operations. Prior to RANE, Kellyn specialized in developing new quantitative analysis methods for defensive and offensive cyber mission sets. She oversaw staff supporting the common vulnerabilities and exposures, MITRE ATT&CK, MITRE DEFEND, and MITRE ENGAGE programs. This is part one of a two-part podcast designed as a tabletop exercise for board members of organizations responding to ransomware attacks. Let's dive into the discussion. We hope you enjoy this episode.
First of all, welcome to the audience. I want to, in advance, thank this great panel that's going to come together and really help give an overview and put some reality around the issues of ransomware. What firms, both in the private and public sector, have to think about in advance, in the moment, and after the fact. The benefit we have here is we have individuals who have actually been through multiple real-world events where ransomware attacks have occurred, and they're going to apply some of the great insights and lessons that they've acquired along the way. We have an interesting scenario. We're going to throw some variations into this, but to begin with, one general observation is that ransomware attacks purposefully often occur at the worst possible times when people and firms are least prepared, whether it's on weekends, during holidays, after hours, etc. They happen quickly, they require quick decisions, and there is a need very much to make sure that firms are surrounded with the areas of expertise that are best equipped, most equipped to obviate, mitigate, respond, etc. And as you'll see from the backgrounds of and the insights of our great panelists, there are a multitude of what I'll refer to as core competencies that are required to manage these situations in an effective way, and obviously to build in the resiliency and the preventative mechanisms that these attacks require. I will also note, as our panelists have been informed us repeatedly, these incidents are no longer rare, and they're certainly recurring, and in fact, they are increasing. So there isn't yet an appropriate government response or safety net for firms. Very much they have to operate on their own, but then ultimately in coordination with, very often with law enforcement, regulatory, outside legal counsel, public relations experts, and people who are used to the negotiations. So with that said, let me begin by giving the scenario. We have a company that we refer to as New Eclipse. They are New York based, but they are global in nature. It's a fintech company that provides credit card and other financial and monetary processing services to not only healthcare facilities, but also to a wide range of other transportation spaces and also in terms of other financial institutions. We've experienced a system outage after work hours. We've been notified of this. It's prevented a number of healthcare and other providers from processing payments and otherwise accessing their records. The IT and InfoSec team at New Eclipse, quite frankly, is investigating, but they're very much stymied. And they've learned not only that their network logs are inaccessible, but it looks as though very sensitive and confidential email communications and other data concerning their client base have been compromised and otherwise misappropriated. The attack has cut across the broad spectrum of clients and billing practices. They're unable to process transactions. They're unable to communicate with their clients. And they're also seeing their clients' data uploaded and potentially compromised. As often happens, the senior management is unavailable. They are mid-flight overseas. The CEO, the CTO, the CFO, the COO for an investor conference. At best, they have some limited Wi-Fi connectivity, but it is not proven to be particularly reliable in trying to communicate. So maybe I'll begin here with the following question, which is, who do we need around the table to begin to understand the process, the response, and what we need to have done? And I'll throw that out to the broad panel. Anyone want to jump in?
I am happy to take that one to start. As you said, the InfoSec people are working on this and they have their role, but that's a separate path. We need a group of senior executives from the company, legal, forensics, and strategic communications to be working at a higher level to discuss issues that involve reputation, decision-making that is not related specifically to solving the technical matter at hand. So that's my take. That's very important to get them in place quickly and to meet frequently to stay up to date on the latest information available.
Rahul, you are our counsel. We've called you. You're in Europe. We woke you up in the middle of the night. We've told you.
Yeah.
You never sleep, right? Sharks do not sleep. So we're assembling virtually and in person the boardroom here. We've also brought in one of the heads of our board to understand what we're doing because we're going to need some decisions. What are you beginning to advise us?
Well, one of the first things that's necessary to try to investigate from a legal perspective is what information has potentially been compromised. Obviously, that's critical to know from a business perspective to understand how material this potential incident might be. But from a legal perspective, the information that's critical to know is what information has been impacted and for what individuals. And that goes to whether you're going to have an obligation as a company to notify individuals impacted, whether that's customers, employees, or anyone else whose information the company maintains. The reason why that's critical, not only to comply with legal obligations, but once individuals start being notified, with a legal notice, that obviously has follow-on effects for the company's reputation, with investors, with the media. And so really that's one of the first things that we focus on from a legal perspective. There are other factors, obviously, if you're a public company related to disclosure, that's the typical materiality analysis applied to the cyber context, both from what impact is this having on the business quantitatively and qualitatively. And there are now timing requirements to make filings with the SEC for public companies within 4 days of a determination of materiality. That last part is key. There has to be a materiality determination. But that has really changed the landscape in the last couple of years.
So Rahul, we're going to put up on the whiteboard in the boardroom, we have to know what information has been compromised. We have a partial view, so we're going to assign our IT people to make the best determination, because down the road, there's disclosure, regulators to clients, consumers, possibly other authorities. So we will do that. But right now, we're sort of trying to change the tires on the car while it's going 60 miles an hour. What we do know is our systems have been locked down. We do know that we're starting to get calls from clients who are wondering what has happened. Fortunately, the markets have yet to open. They won't open until 9 a.m. Eastern time. So our share price is, not yet at risk, but information is starting to flow outside. We have thought to contact our insurance company to let them know. And fortunately, Ms. Ramsdell is on the scene now in our boardroom and beginning to advise us how to unpack this and understand the nature of the threat. So would you tell us just a little bit about what you're going to be doing in the boardroom, what we need to do right now?
Absolutely. So in the boardroom, the responsibility of your IT and information security and incident response teams are to give you those critical decision points, right? While we run the very technical incident response processes. So in addition to Rahul's point about identifying which data was accessed and or potentially stolen, exfiltrated from the environment, we're also going to be looking at which systems and reporting that back to you, because that informs the timeline for recovery. Are they down? Are we simply locked out? Is there encryption? There's multiple layers that inform how long it takes to recover. The critical priority there is also assessing our backups. What is there and how quickly can we get those back up and running? Because that is the most critical thing your technical people need to be communicating to your decision makers during a response. It is, what is the timeline for recovery? That's when you start to get those additional questions regarding who is doing it, the threat actor, and your next follow-on steps. You need to know for your existing critical systems, how long does it take to recover those in addition to what data was stolen?
Now, unfortunately, we did not implement redundancy in the cloud. This is, I guess, one of the lessons we're going to learn for the future, which is the importance of having such redundancy, but we don't have it right now. And as a consequence, word is leaking out. We have clients that are calling on a regular basis. Kelly, I think it's fair to assume this is not going to be a secret very long, that just between the number of sources that cover businesses, no less social media, et cetera, our employees, many of whom work remotely, are noting that they can't get access. So there's chatter internally about what is happening here. Our management team is still in the air, and we need to obviously get communications out internally, externally, et cetera. I assume the notion is to at least get ahead of this a little bit, and I guess that's a term that's used. But between you and Rahul, what should we be saying, and to whom should we be saying at this point, where we don't know the sources, we don't know the extent, and we don't know whether we are going to be able to basically get back online and have control again, to Kellyn's point, anytime soon?
Okay, so I have three subsets of answers to that. Number one, in a situation like this, the first question is, do you have a cyber comms plan to support your incident response plan? That means you're not starting with a blank sheet of paper. You've considered your own culture, you've identified your audiences, and importantly, identified the decision makers. I have seen in more incident than one, the CEO or somebody critical being out of pocket and nobody knows who's in charge. So identifying those people is critical. At the early stages, when it's clear that something has happened like this, I mean, this isn't one you can hide from, but you have to take a very circumspect approach in what you're saying. We have to say something, and we decide whether it's reactive or in some cases proactive. But importantly, being transparent, acknowledging that something has occurred without getting ahead of our skis and providing information that is going to panic people unnecessarily or that turns out to be inaccurate later. If you are inaccurate in your statements, walking that back later is very difficult.
Okay. And just so everyone knows, the abbreviation you used, cybercom plan, is a cyber communications plan.
That's correct. It's the various scenarios and like what would those statements be? And each situation is different, but what would our starting point be that we've all hashed out in advance and people have generally agreed to? Again, so we're not starting from a blank sheet of paper, which makes it much more challenging.
Okay, so something has to be said because word is out. It's not, we no longer have optionality on this. And Rahul, your counsel here is going to be absolutely critical because there are different constituencies. There's obviously the public markets, we're a public company. There's internal communications, there are client communications, and law enforcement and regulators as well. How are you, not meaning to throw all those balls up in the air, plus we have our management team that's still 30,000 feet in the air, but we do have a board member here. What are you thinking about? What are you advising?
I mean, really to emphasize Kelly's last point, which is, typical role of the lawyer advising not to get out ahead of your skis. That's important for all the credibility reasons that Kelly referenced, but legally, that's really where companies have been tripped up in the past. Not that there is an intent to mislead, but there's often business pressure to say something reassuring. And in the scenario, we don't really know much yet. And things obviously can and will change. And so really the whole team working together, counsel, management, the PR advisors, communications advisors, to come up with something that satisfies the various stakeholders is really an important first task in a scenario like this. Once a statement is made, if material information is learned by the company, and they're a public company, and the information is not updated quickly enough in the SEC's view, the SEC has brought cases on that theory that there is a duty to correct inaccurate information. And so there may be a need to put something more specific out there, but need to understand the risks in doing so. And if specific information that's subject to change is stated publicly, then the whole team, including counsel, of course, will be on guard to see if that statement needs to be updated in the future.
And I will just add that comms is our firm is typically engaged by the law firm. This becomes a legal matter the minute something occurs, so we want to make sure we are working in lockstep on messaging to make sure that we're protecting the company to the extent possible.
The other thing I would mention, David, one of the audiences you didn't mention out there of these statements is the threat actor itself.
Getting there. We are definitely getting there.
They will be reading everything the company puts out. And so that is something that needs to be taken into account potentially.
Let me just summarize, because we use terms such as getting ahead of ourselves, and the metaphor is always ahead of the tips of the skis. What you guys are actually saying is basically, if you don't know, we have to say we don't know. And we cannot make promises or representations that ultimately you have to be on guard, ultimately may prove to be inaccurate, notwithstanding our best intentions. So everything has to be cleared. Rahul, are you enveloping the boardroom with attorney-client privilege in terms of the communications? You have people who are now, working under your direction and supervision in conjunction with the company. Is that an important consideration as well?
It's a very important consideration, and it's a very hot topic. There's a lot of litigation and discussion over what information can and should be privileged during the response to a cyber attack. I'd say generally the rule of thumb that the courts have laid out is if work is being done and communications are being made primarily for legal purposes to address potential legal liability versus pure business purposes, then information can be privileged. So a few lessons from the cases and the law generally. One is to get counsel involved early. Two, as Kelly mentioned, is to have advisors, including the communication advisors and forensic advisors, engaged by counsel. It's fine to use advisors that the company has used in the past, but I would say if the company does that, it's critical to do a new agreement or a new statement of work that's very specific that this team, this project is for the cyber response and to help advise counsel in representing the company. Third, some courts have even focused on how are the advisors being paid? Is this coming out of the legal budget versus the business budget? So that's one thing to keep in mind. I would then finally, probably the biggest but trickiest factor here is how are you drawing lines around your privileged channel? Not everything is going to be privileged when you're responding to an incident. The courts have said that because you would respond to the incident even if there was no legal risk. There's obviously a lot of business reasons to take the steps that companies take when they're attacked. So you really want to be thoughtful about upfront, discuss with counsel, what is the information that the company really cares about and that's going to go into the legal liability assessment, and make sure that information is treated as privileged, including only involving and sharing reports and communications with those who need to know. And I would just add at the end, the legal steps are very important to preserve the company's options and limit potential exposure. But there are always situations where the business needs of the company may supersede, for example, the decision around who to share a forensic report with. There may be very, very compelling reasons to share that with, for example, business partners who might be concerned what's going on with the company. And so that does happen, and that's a discussion. It's an exercise in preserving your legal options and making sure that you're aware of the potential downsides of taking certain steps.
So we have not just a substantive issue that we're dealing with, there's a process issue. And the main takeaway here, without getting into the fine points of preserving the privilege, there are a number of things that will occur during these attacks. And you want to have outside counsel being thoughtful about setting up the channels of communication, the work stream. If people are outsiders are being deployed and put under agreement, thought to that. And what I will just say to the audience, which is very often the case, when these things do break, notwithstanding, legitimate claims of privilege, the government may very well ask the company to waive the privilege and to share the information, which becomes another consideration. But nonetheless, there are process points that must be considered. Tell us about the progress you've made in figuring out who's behind this. And we've just received a ransomware request and a threat to expose, not only to keep our systems locked down, but to expose confidential business plans, email communications of our company, as well as our clients on the dark web if the ransom is not being paid.
So the first step, once you get that demand, and it's really twofold. So for your decision makers, will you pay? There's a lot of other considerations, but some do come in and they say, no matter what, we will not pay a ransom. That is the ethos of our company. We won't do it. And so that's always a question to encourage early before you're in the event, because some say, no, this is our policy and we're going to do it. Okay. We have different steps we can follow. But we need to know who that threat actor is. We need to take every identified artifact associated with their operations and not just say, okay, the threat actor says they're this person. They say they're this group. Are they really? Is this somebody else pretending to be them for some reason? Because we need to now start going through the, will you pay? Maybe you don't know. Maybe you're uncertain. You're not one of those firms that comes in and says, no, we will not pay. You come in and you say, let's find out. All right, so now we start walking through the various negotiation strategies with the threat actor. We want to know, is it legal to facilitate a payment to this threat actor? So we need to assess sanctions exposure in the countries.
Those are U.S. and international sanctions. These are laws that are on the books, prohibited parties making payments, transaction business with them, et cetera. Okay.
Absolutely. So in the United States, it's going to be administered by the Office of Foreign Assets Control. There are then other sanctions regimes. So any country in which you operate, we want to check the sanctions exposure. So it's really critical that we know every single thing about the threat actor to not only go, okay, who are they? And then are they associated with an individual? Have they maybe changed brand names? But they are actually still operated by the individual who is listed on, in the United States' case, the OFAC, Specially Designated Nationals list.
I was just going to add on OFAC, they have made public communications saying that victim companies are not off the hook from making payments to ransomware actors just because they are a victim of extortion. They have not brought that type of action yet based on against a corporate victim, but they've said it's on the table, and they've emphasized in the civil context, at least, the liability is strict liability, meaning that theoretically, even if the company is not aware that it's making a payment to a sanctioned party, it may still be civilly liable.
Okay, so let me play the board member. Great, guys. You're telling me I'm being extorted. You're telling me I may not be able to pay. There's a Damoclean sword hanging over this company. And in the meantime, we have important clients and customers who expect us to fix this. Their businesses are down. What else we have to be doing here to possibly resolve this and get to a decision point? And I, as a board member, I recognize, what our culture is, but our culture may just be a guideline. Okay, because if we don't have a business at the end of the day, our culture is not worth anything.
Absolutely. And this is where working with counsel is so critical, because a core decision is, do you engage with the threat actor? Do you contact them? And then what do you ask? What is your strategy there? And that in part depends on what you're hearing about the state of your backups and your data. We know here we're in trouble. So we can engage the threat actor to find out what is the ransom demand. That is typically not provided in the initial extortion event. They give you a timeline.
We just got a communication. It's 3.75 mil.
All right. Now we can go forward. Is that standard for that threat actor? Now you want to work by working with a firm that's experienced with this. What do they typically negotiate down? Do they reduce the payment? And what is your strategy for that? So are you going to, one, verify, regardless, actually, You need to verify that the threat actor has the capabilities they're extorting you for. Do they have your data? Can they provide a file tree? Can they provide any proof of what they stole for you that they're claiming they will delete upon payment? Secondly, because there is an encryption event associated with the loss of access to systems, we need to identify, can the threat actor actually decrypt data? Typically, you're going to find that out by sending sample files of non-critical data for the threat actor to validate decryption. Now, that's the direct engagement with the threat actor. You also need to know the threat actor's history. When they provide a decryptor, does it typically work? If it's a new group, very rarely is there a fully new group. They've evolved from someone else, so we want to look at that history there. Do they typically steal the data? Do they lie about how much data they stole? Hint there, they almost always lie about how much they stole. So we have to go through that history of how much should you believe this threat actor, and is it worth that money? If in that engagement you determine yes, payment is still likely, we have now gathered even more data as the investigation has been going on to go, who is this threat actor? What has the communications from your environment been from a technical perspective? So we can, again, further do that due diligence on who is this threat actor and what is that sanctions exposure to which you're opening yourself.
That's all consistent with my experience. The only other thing I'd add, we haven't discussed yet opening up a channel of communication with law enforcement, but
that's what I'm going to ask next, Rahul.
Okay,
that's
got
you talk to the regulators. Are they working in lockstep?
Yeah.
Do they know, et cetera? And let me I just want to back up one thing. In terms of these negotiations, it is implicit. And by the way, Kelley is waiting with bated breath in terms of what she can in turn tell the markets and to indicate some degree of progress in this thing. But what is implicit here, it's not just opening up negotiations, it's who is opening up negotiations, who is speaking on behalf of the company, who is communicating with the other side. And you want people, the old axiom of kids don't try this at home. This is not something that companies should be engaged in on their own. You want people who are experienced with these actors, know how to communicate, know what to say, et cetera. And obviously, and I'm going to get into your point about, is law enforcement regulators involved yet? What guidance are they giving? They may have intel on the group, et cetera, and you want to share that. But one of the things that we've spoken about is, while these crimes are new from a technological standpoint, new portals, there is I'll call it an analog in the physical world to kidnapping. Some of the very same questions that people ask when there is a kidnapping, and that's why the FBI has particularly deep experience in this, is you want to know that the group that's calling with the ransom actually is the group that's involved. There's, I'll call it proof of life, that you sort of have the individual and they're alive, and there's someone that can be returned. There is a negotiation that often goes on, and then of course, if you do negotiate and decide to negotiate as opposed to refuse the demands, how do you know you get back what you're bargaining for? Okay, and how do you know it's not going to happen again and again? So I just to simplify what we're going through here, and again, in a traditional kidnapping, you have communications experts, you also have legal advice, you have law enforcement, and hopefully you have people who are very experienced in the negotiation. So, Rahul, you were about to jump in with a very important critical decision for the company, whether law enforcement is engaged.
Yes. So we typically see that law enforcement is engaged in these situations, especially such a serious situation as the scenario we're discussing. There are different levels of engagement. There are notification forms that can be put into the FBI, which will alert law enforcement to the incident. And then there are more proactive measures that are also taken by certain companies. And that's reaching out to FBI agent who the company is familiar with or counsel is familiar with, who's either focused on cyber or someone that is liaisoned with the company in the past. And going back to the discussion about sanctions and compliance, that's another source of information that could potentially give the company some level of assurance on the compliance front. Our experience is that the FBI will try to assist. They treat corporate victims as we see them, as victims, and will give whatever help they can and provide information that may be relevant, such as if law enforcement has any view on whether this threat actor is associated with a sanctioned party. They may offer some additional IOCs or indicators of compromise that the forensic advisors or the company could use to try to narrow down who the threat actor is. The downside is potentially once you're having an active engagement with law enforcement, they may have requests of the company. They may not be burdensome, but they could become burdensome over time. And so the company has to weigh that. And there have been investigations of companies themselves. The federal government, as far as I am aware, does not investigate cybersecurity readiness of companies, meaning the criminal authorities, DOJ, and the FBI. But if other crimes are committed in the course of a cyber incident, we've seen cases like insider trading investigations, obstruction of justice investigations. And so anytime you involve law enforcement, there's that risk of an investigation taking a turn that you didn't expect. But generally, we do see for major incidents, for major companies, there's some level of notification and communication with law enforcement.
Again, a managed process, Rahul. I actually want to unpack, because you said a number of very, very important points. So look, there is now material inside information about the company. It's a publicly traded company. And that information has a value in the marketplace, okay, in terms of the nature and scope. And so obviously, Kelly, you'll be careful in the messaging that we give to the markets, but people do have to be reminded to not share this information with outsiders, and obviously not to trade. The point about the FBI and what might be requested, just to unpack that a little bit, they might want to have access to the systems to see what they can learn and to be helpful. There are also, questions that might arise afterwards, which damned if you do, damned if you don't. Why didn't you call in law enforcement sooner? That could have been of assistance. They may also have a view about whether ransomware should be paid, whether formally or informally have that view. And so, just to your point, Rahul, there are a multitude of considerations. This is probably the area where perfection is the enemy of the good, because there'll be no perfection. And I know that the FBI has taken great pains to try to communicate with the business sector that we will be aligned. We are not here to embarrass. We're not here to, disclose certain things. We're not here to take advantage of an exploitation and rummage around your systems. They have tried very hard to demonstrate and communicate what I'll refer to as the public-private sector initiatives around this. And so, again, I would just say management of that process with outside counsel, knowing a trusted representative of law enforcement. I'm taking those as very important, not only lessons, but steps that in advance a company can take to prepare for these types of situations.
Yeah, that's exactly right. Just one point I'd make is that on the FBI and DOJ, you talked about the pains they've taken to communicate to the business sector. The SEC and other civil regulators have brought cases, have brought investigations of victims of cyber attacks for potential disclosure of violations. We alluded to them earlier. And then other regulators under their own jurisdictions have also investigated corporate victims for either not accurately making representations to consumers. That's the FTC hook. Banking regulators have their own jurisdiction over safety and compliance in banks. And so I just want to note that there is a distinction between the federal government here and what perspective they bring to these situations.
And a consistent view is not what's the Emerson quote about what I'll refer to as simple consistency being the hobgoblin of small minds. The government's entitled to have a multitude of views on a particular situation. To your point, there's the SEC. There could be banking regulators. There are congressional investigations that get convened. And of course, we have class action lawyers who, will be looking at this. And once again, there's a legal issue. So, Kelley, we have some pieces here. We have, although our executives are still over the ocean, we have board leadership. We have brought together outside counsel. The appropriate authorities have been contacted. We have appropriate forensic people who are working on this. And there has been a ransom request. What are you suggesting? And word is leaking out. I mean, it's you're reading about what's going on in the company on social media. Bloomberg's calling in, et cetera, et cetera. What are you potentially putting together as a potential communication for the company, both externally, internally to their employees and to their clients and customers?
Well, now it definitely has to be updated from presumably the first statement, and maybe even there was an evolution beyond that one. Sometimes at the very outset, you can get away with a data incident, then maybe it evolves. At this stage, we need to, again, identify the stakeholders, acknowledge that the threat actor has made this claim without acknowledging that they're to Kellyn's point, it might not even be who claims the threat actor may not even be who they claim they are. So we acknowledge that this claim has been made and that data has been allegedly posted on a shaming site and that we are evaluating it. But it's looking at all of your audiences. Do we need to look at your top tier customers and do something more proactively with them? Or do we do everything reactively? And at all stages, but at this stage, it is very important to not panic and think this is turning into a bigger issue than it may be. I mean, it sounds like it probably would, but if you're not getting very many employee questions about this, if you're not getting customer demands, if the media isn't really covering it and you've just gotten the one inquiry, can you stay reactive? And this is the reason that the advisors need to hold these regular calls to discuss the situation real time and what's our best course of action at this stage. On the law enforcement point, we don't weigh in on that. That's the company's decision with counsel, but it is a very good communication point that we are involving law enforcement because it shows that we're taking the matter very seriously. Just getting back to another of Kellyn's points, on planning ahead, we really like to see clients develop a tightly held decision tree on pay or no pay. An issue like this that's involving healthcare and private data, it would have been good to look at that in advance. And companies who pound on the table and say, I'm not going to pay, after a couple days, weeks of being paralyzed, sometimes they change that very definitive position that they've had. But evolving the communication now, deciding whether to communicate with media and other stakeholders is obviously critical at this phase.
Okay.
And if I can,
please.
If I can add to what Kelley was walking through there, some critical points that your forensics and or negotiations firm should be advising is whether the threat actor has a history of contacting the media themselves, whether the threat actor has a history of calling or contacting a victim's clients, and then whether they also have a history of calling or otherwise harassing with internal applications and employees, because many threat actors have evolved their pressure tactics, is what we typically call them, in the last few years, and they become very persistent. They notify clients, they reach out. So if you do not have a communications plan, the threat actor might be deciding it for you.
Thanks for listening. Stay tuned for part 2 of this tabletop exercise and subscribe to the RANE podcast series wherever you get your podcasts.